I don't know the answer. I don't know the answer to that, but we do know that if
Good morning, everyone. Welcome, welcome. So glad you're all here. It's right about 11 o'clock. I guess we'll get started. Again, I'm attorney Ted London. This is our fourth, I think it is. Actually, it's third. This is March. This is our third 2023 African American Wealth Transfer Series. And we're giving seminars every first Thursday of the month to share information with the African American community about estate planning. So often people have so much misinformation about estate planning, and it causes their families to lose a lot of money in the interim. So we want to share some information with you and your family, so you can make good decisions. Because again, what we've discovered is when people have good information, they make good decisions. I hope you all have pens and paper so you can take some information down. Let's start with our address and our phone number here. You can always come by our office, or you can always give us a call. Again, our address is 1718 East 87th Street. That's in Chicago. That's a block and a half east of Stony Island on 87th Street. Of course, you can always call us at the office. Number is 773-721-3333. Additionally, you can go to our web page at tedlondon.org, or we have a Twitter account, and we have a link tree. So you can actually go to our link tree, and that gives you all the information about our social media positions. That you can get additional information. We have a YouTube channel where we share information, videos, and those sorts of things. So please follow us on the social media platforms. We are going to be taking questions from you this morning today. We have my assistant Jada Lynch on. She's on with us, so she's going to be, managing this whole process for us. So if you have questions, I think there's going to be a chat bar that you can type questions in, and then we'll take your questions as well. So again, I'm attorney Ted London. We are here today to share some information with you about estate planning. And so let's jump right in. When we talk about estate planning, really the number one objective that we want to accomplish for our clients is to keep their assets out of probate court. Probate court is expensive, it's time consuming, and it's stressful. So we want to avoid probate court for our clients. That's the number one thing that we want to accomplish. In that regard, we don't do wills. We don't do wills for our clients because if a person has a will, their loved ones are going to have to go through the expensive, time-consuming, stressful probate process. And so let's repeat that. Yes, it is true. If you have a will, your loved ones will have to go through the probate process. A will does not keep your things out of probate court. A will send it through the probate process. So believe it or not, rule number one for efficient estate planning is no wills. So For most middle-class families, there are three primary things that we want to keep out of probate court: real estate, persons, and the money. Those are the three primary things. We don't really spend a whole lot of time on what they call personal property. That is, we don't spend a lot of time on jewelry. We don't spend a lot of time on fur coats, those kinds of things, because the reality with those things are personal property, that is, you know what, first come, first serve. First kid gets to the fur coat, it's theirs. They'll lie about having the coat, but then they'll wear it to the service. That's the way it is. You know, first person gets the wedding ring, it's theirs. Not really much you can do about that. Those things don't really have to go through the probate process. So you don't really need a will or any estate planning to say who's going to get your wedding ring, who's going to get your fur coat, because the reality is first one gets it, they're going to be, it's first finders keepers. Okay, so, but the things that would have to go through the probate process would be the real estate, would be you, the individuals, and thirdly, the money. So those are the three primary things that we want to keep out of probate court. So let's start with the real estate. How do we keep the real estate out of probate court? And when we talk about real estate, we're talking about your homes, we're talking about investment properties, multi-unit properties, single-family homes, and this is whether the homes are paid for or not. All of them should be protected against the probate process. Typically, we advise our clients to put their properties in some sort of trust. There are a number of types of trust. There's a land trust and there's a living trust. Normally for our clients in Illinois, in the Chicago area, we just prefer that they put their properties in a land trust. And having the properties in a land trust has a number of benefits. The first benefit of a land trust is you get to name who gets the property after you, and whomever you name gets it very easily without going through the probate process. You can name all the kids or just the good one, that's up to you. But whomever you name will get the property very easy without going through the probate process. You still own the property 100% while you're living. Whoever you name to get the property after you, they have no interest in the property at all while you're living. And if they get on your nerves, you can always change them very easily. But if you have your property and land trust, one of the benefits is, again, you get to name who gets it after you, and they'll get it very easily without going through the expensive, time-consuming, stressful probate process. That is one of the benefits of having a property and land trust. Another benefit of having your property and land trust is if you have your property and land trust, if you are ever sued, the judgment does not attach to your property. So if you have your property in your name personally, if you are ever sued, if that judgment is recorded, it automatically attaches to any real estate that you have in your name. If you have your property in a land trust, it does not. So we get many people who come in who want their properties in a land trust because perhaps they have multiple properties. One property may be getting foreclosed on, and then they want to make sure the judgment of the foreclosure doesn't attach to their primary property. So they put their property in a land trust to stop that judgment from attaching. We've had people who have been in car accidents, who've actually killed people in car accidents, came in to put their properties in a land trust because they wanted to make sure that if they were sued, the judgment would not attach to their real estate. So another benefit of the land trust is that it keeps judgment from attaching to your property if you are ever sued. The third benefit of a land trust is there is a privacy benefit. Once you put the property in a land trust, if someone runs your name, they're not going to be able to find out what property you own. And if they run your property address, they are not going to see that you are the owner. And so we have a lot of pastors that come in to put their properties in a land trust. We have a lot of elected officials who come in, put their properties in a land trust. We have a lot of judges, a lot of business owners, a lot of retired police officers and educators who put their properties in a land trust because they like the privacy benefit. If you don't have your property in a land trust, someone can just go to public records, Google your name and find out what property you own, or they can go to public records and Google your property address to see who owns that property. If you have your property in a land trust, they will not be able to do that. So the way that we keep the real estate out of probate court is typically with a land trust. Again, there are a number of benefits to the land trust. One, it's going to stop the property from going through the probate process. You get to name who gets it after you. It's going to stop judgment from attaching. to your home if you're ever sued. And then there's the privacy benefit that no one's going to be able to just go to the Record of Deeds website to put in your name or your address and find out what property you own. There's another benefit to a land trust as well, and that is it stops property theft. There's a lot of property fraud going on where people are just preparing deeds, recording the deeds, and transferring people's homes to someone else's name fraudulently. And then this happens and the homeowner doesn't even know that it has occurred. And then what happens is once these people, they fraudulently transfer the property to themselves, then they refinance the homes and get money out of the home. And then the homeowner doesn't even know this. So that's a very common thing that's going on really all across America these days. That's property fraud. Well, a land trust does also help against property fraud because now you have to go through the title trust company to transact some of these things. And that is just another layer of protection against property fraud. So the bottom line is when it comes to real estate, we want our client's property to be in a land trust. Again, you're going to control it and you get to name who gets it after you, and then whomever you name gets it very easily. Again, they don't have any interest in the property at all while you're living, but they'll get it very easy once we pass away. You know what? We oftentimes get people who will come in with their children and they want to add their children's names to the deeds of their property. Well, I am always adamant against that because if you add your children's name to your property, if your child is sued, then that judgment can be collected against your property. So you never really want to add anyone's name to your property. We want to set it up where whomever you want to have the property after you will get it very easily without having to go through that expensive, time-consuming probate process. And with the real estate, the way we do that is with a land trust. Now, secondly, we want to make sure that we keep you out of probate court. People can go to probate court while they're still living. And so you have to make sure that you have someone in a position to be able to make health care or business decisions for you if you ever need someone to be in a position to make health care or business decisions for you. And the way that you do that is you have to have power of attorneys. There are two kinds of power of attorneys. There's one for health care and there's one for business matters. Everyone needs power of attorneys. And here's what's interesting. We have many clients who've been married for 50, 55, 60 years, and they are always surprised to learn that even after decades of marriage, that they cannot make decisions for one another without having power of attorneys. So just because you're married to someone does not give you the right to make decisions for them if you ever need to do that for them. Just because you're someone's parent does not give you the right to make decisions for them if they're adults. Just because you're someone's adult child does not give you the right to do that. You have to have the power of attorneys. And again, there are two kinds of power of attorneys. There's one for health care, there's one for business matters. And again, what the healthcare power of attorney does is it allows you to name someone to be in a position to make health care and business decisions for you if you ever need someone to make them for you. What the power of attorney for property does is it allows you to name someone to be in a position to make business decisions for you. Sign checks, pay bills, deal with Social Security, deal with pensions, any of those kinds of things. So there are two kinds of power of attorneys. Everyone needs them both. Okay, and for both of those power of attorneys, you get to name a primary person to be in a position to make decisions for you, and you get to name a secondary person as well. But everyone needs power of attorneys. Now, this is especially for you ladies out here, because so many of you ladies are caregivers, and you're going to be caregivers for families, friends, relatives. And so you have to make sure that you make it easy on yourself to be in a position to care for some people that you have to look down the road to see that I'm going to need to be in a position to make decisions for them down the road. And the way that you do that is you have to make sure that you have power of attorneys for those people that you may be caregivers for, parents, grandparents, aunts and uncles, sometimes neighbors. Here's what I find interesting. We get more people than I thought that bring in ex-spouses to make sure that the ex-spouse has their affairs in order. Typically, it is an ex-wife bringing in an ex-husband to make sure that his affairs are in order so their children will get the home and the money and someone's in a position to make decisions for their husband without the children having to go through some complicated process. So I am always surprised to see ex-spouses come in. And again, sometimes we have ex-spouses where they're leaving money in real estate to an ex-spouse. I find that very charming that ex-spouses can really communicate and still support one another, really for the benefit of even adult children. But we see that more than I suspected that we would. But here's the bottom line, particularly for you ladies, because we know men are not typically caregivers. More often it's going to be a lady. So for you ladies out there, again, for people that you may need to be in a position to make decisions for down the road, the way that you get yourself in a position to do that are to have the documents. Everyone needs to have the documents, whether you're married or single. You have to have someone in a position to make decisions for you if you can't make them for yourself. Many of you know that if you've gone to hospitals before, one of the first things that they're going to ask you for at a hospital is, do you have a power of attorney, or who are the power of attorneys? Well, if you don't have them, that can create a real problem for a family. And so you have to avoid that by having the power of attorneys before you need them. Because we often get calls and we often get people who come in for consultations and they need power of attorneys for their loved ones, but the loved ones are incompetent now and they are not in a position to sign the documents. And so that's because perhaps age, Alzheimer's or dementia is really, really prevalent. Sometimes people have had surgery and they are in comas. And just because you're in that position, life still goes on, expenses still need to be paid, decisions still need to be made, and someone has to be in a position to do it. But if you wait too long, which we see very, very often, and you need to be in a position to make decisions for someone, and they are not available to sign the documents, then you have to go through the expensive, very complicated probate process to be appointed their guardians. Okay, and again, that can be easily avoided by having the power of attorneys done before you need them. You cannot wait until the last minute when someone's in the hospital, someone's aging, someone has dementia, and try to get these things done. It makes it much more difficult for everyone if you wait to the last minute to get these things done. You have to get them done before you need them. So the way that we keep our individuals out of probate court, that is you, your families, your spouses, your loved ones, people you're going to be in a position to care for down the road, is you have to have power of attorneys for them. And you have to have them for yourself. Here's what's interesting. Even parents need power of attorneys for their college age children, because we've had a number of families come in over the years and their children have been at college and some of them have had medical conditions. And because the children were over 18 years old, the hospitals and the healthcare providers would not give the parents any information about their children. And so you have to have power of attorneys for them. So even if you have children 18, 19, 20, 25 years old, you probably want to make sure that you have power of attorneys for them as well, because in the event that you need to be in a position to make decisions for them, get healthcare information about them, you're going to need the documents. Just because you're their parent does not give you any right to make decisions for them. So whether you're 18 or 88, everyone needs to have power of attorneys. And that's going to keep you out of the probate process in the event that someone needs to make decisions for you, or you need to make decisions for someone else. So again, we're talking about estate planning here, and we're going to talk about a number of other things down the road as well, beyond estate planning. We're going to talk about some insurance issues. We're going to talk about Medicaid spend down issues. We're going to talk about reverse mortgages, home equity, a number of things. But we're going to start off with, again, estate planning issues today. And again, when we talk about estate planning, the primary objective is to avoid the expensive, time-consuming, stressful probate process. So we know we don't want wills, because a will is going to send your family through that process. Let's talk about probate for a minute as well, because oftentimes people aren't really familiar with really what the probate process is. Well, the probate process is a process where if someone passes away and they don't have the kind of estate planning that we're talking about today, that is having properties in a trust, having having power of attorneys for themselves. And we're going to talk about the money part in just a minute. But if you haven't properly set up your estate, your loved one's going to go through the probate process. And so if you have a will, your loved one's going to have to go through the probate process. Or if you have nothing at all, they're going to have to go through the probate process. Now, I'm just going to give you a little bit of inside information about lawyers and probate. Well, the bottom line is lawyers love the probate process. We love it because it's a very lucrative area of practice. And right now, we are that is Americans, we're in the midst of the largest, greatest wealth transfer in the history of the world. Baby boomers are leaving more money and more real estate to their children and grandchildren than any time in the history of the world. So there's a lot of money being transferred from parents and grandparents to children and grandchildren. And if you don't do it efficiently, then your loved ones are going to have to go through the probate process, and lawyers are just going to really do very, 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 very well. And so most lawyers don't really share information about how to keep your things out of probate court because they make a lot of money doing the probate process. That's just the bottom line. And here are a couple of things that lawyers do. I hope there's not a whole lot of lawyers out there listening to this because I'm telling some secrets. But here are some things that lawyers do to make sure that your loved ones are going to have to go through the probate process when you go to heaven. One of the things that they do is they prepare wills for you. If a lawyer is preparing a will for you, or if you have a will, that is not an efficient way to transfer your money and your real estate to your loved ones. And smart lawyers do one of two things to make sure that once you go to heaven, if they've done a will for you, that your family comes back to their office to make sure they make the money on the probate. Here's one of the things that they do. We will actually write ourselves into the wills. So if a lawyer does a will for you, and if he is a smart lawyer, and if some of you have wills out there, you should double check your wills to see if your lawyer was a smart lawyer or not. But the smart lawyers will actually write themselves into the will. Nothing illegal about it, nothing immoral about it, nothing wrong about it. The only thing that the lawyer will say is he'll put one paragraph in the will that says, I, Attorney Ted London, will probate the estate of XYZ. That means when XYZ goes to heaven, your family's going to have to come to Attorney Ted London for me to probate the estate because I am as much in the will as the children are. And then I'm going to just bill. So really, I can set up a really lucrative practice by doing wills, writing myself in the will, and then when our clients go to heaven, the loved ones have to come to our office, and we're gonna do very, very, very well. So that's one way that lawyers make sure that they're going to do well by doing wills for you and your family is they write themselves into the will. Another way that lawyers make sure that when you go to heaven, if they've written wills for you, that your family is going to come back to them is they keep the original will. So because when a person passes away, the original will must be filed, not a copy. So if the lawyer does a will for you, gives you a copy, keeps the original will, when you or your family member goes to heaven, they have to come back to that lawyer's office to get the original will. Now, if you're the lawyer with the will, if you're the lawyer that prepared the will for the client or the family, why wouldn't the family want you to probate the estate? You already have all the information about it. You're the one that prepared it. You're the one that had the relationship with the person that's deceased, whose will you did. And that's just another way for lawyers to make sure that when they do wills for you, that your family is going to have to come back to their offices and probate the will. Here's another reason why you want to avoid the probate process is because if your loved ones have to go through the probate process, your creditors have an opportunity to make a claim in the estate, and that's going to diminish the amount of money that your loved ones would have been entitled to. Let me give you an example. I had a client that passed away maybe about a year or so ago. He was married. He was in mid-40s. He was a high school principal. Passed away after a very, very short illness, unexpected. He was married, had one child. They had a beautiful home over in the Beverly area that was only in the husband's name. And then he had about $250,000 or so in a variety of accounts, no beneficiaries on the accounts. And he had a student loan of about $150,000. He had a PhD, master's degree, a lot of education, a lot of student loans. Well, when he passed away without any estate planning, his wife had to go through the probate process. So they had a minor child, and the minor child was going to be entitled to half of everything. And then the wife was going to be entitled to the other half. So for the minor child's portion, we had to put that into a minor's account where that child's going to get it at the age of 18. But one of the things that did was that diminished the amount of resources that the wife and the mom had to raise the child, because half of it is going into an account for the child at 18. Well, that mother certainly could have used those resources to care for the child. I think the child was about 3 years old, could have certainly used that money to care for the child. Another thing that happened was he had student loans, and the student loans company filed a claim against the estate. So if you pass away and if your loved ones have to go through the probate process, the creditors can make a claim on the estate. And in this case, the student loan company made a claim against the estate because he had the money, and the student loan company, they wanted their money. So we were able to negotiate that claim down to about half of the $125,000. So $60,000, I think, is what we were able to negotiate it down. But again, that was $60,000 lost that could have been avoided being paid to the student loan company had there been sufficient efficient estate planning. Okay, so she had to pay money to the student loan company. She had to pay some other resources. She had to pay some filing fees. She had to get a bond. And who else did she have to pay? Me. All of that could have been avoided had they done some straightforward, very economical, reasonably priced estate planning. So that's one of the other downsides of having to go through the probate process is all of your creditors have an opportunity to make a claim. Hospital, cars, credit cards, healthcare providers, student loan companies. If you keep your assets out of probate court, they can't make claims on your estate. And so that's another real important reason why you want to avoid the probate process, is because, again, you don't want to have to pay those claims out of your estate after you have passed away, which is going to diminish the amount of money that your loved ones would otherwise be entitled to. But again, the probate process is a long process where you have to go to court, you have to hire lawyers. A lot of people fight during the probate process because even if you have a will, the wills can be challenged. A number of reasons why wills are challenged is people are alleging that fraud was done. People are alleging that, they weren't properly witnessed, that the signature is not valid, that the person wasn't competent, that the person was coerced. These are all reasons, and there are more, that people can challenge a will. Well, I'll give you another secret about lawyers and wills being challenged. Lawyers like it. Why do lawyers like wills being challenged? Because lawyers are billing. And all that money is coming right out of the estate. Okay, so this is all money that's going to diminish how much your loved ones would otherwise be entitled to, because they have to now fight these challenges from who knows where they come from. They come from children, they come from siblings, they come from people who claim to be children. Number of people challenge wills, and again, all to the benefit of the lawyers. So if you do efficient estate planning, it takes all of your assets out of the realm of being challenged by these kind of claims that people will make once the person goes to heaven. So again, there are three things when we talk about estate planning that we want to keep out of probate court. The real estate, we do that with a land trust. We want to keep you and your loved ones out of probate court in the event that someone needs to make decisions for them, and we do that with power of attorneys. Again, there are two kinds of power of attorneys, one for healthcare, one for business matters. Everyone needs them both. And the third thing that we want to keep out of probate for our clients is the money. Those are the three primary things that people fight about. When you go to heaven, they're fighting about who's going to get the home. They fight about who's going to be in a position to make decisions for you, because they think if they're in a position to make decisions for you, they're going to get close to the what? That's right, they think they're going to get close to the money. And then, of course, they fight about the money. So the third thing that we want to share with you about how to keep out of probate court is the money. And when we talk about money, we're talking about all of your financial accounts: checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies, annuities, bonds. The easiest and most efficient way to keep those out of probate court, and it's free to do, is just to make sure that you have current beneficiaries on all of your financial accounts. If you have beneficiaries on all of your financial accounts, and I say current beneficiaries, then once you pass away, then whomever you name as a beneficiary is going to get the money very easily. You can list multiple people as beneficiaries. You can list people in percentages as beneficiaries. So as long as you have current beneficiaries, then you're going to be in good shape. Now, I say current beneficiaries because we often find people who have beneficiaries on the accounts with people that have passed away already. We have people who are listed as beneficiaries, people they're not married to any longer. Some of you have beneficiaries that for people that you don't like anymore. Some of you have beneficiaries, people that you don't even know where they are. You haven't spoken to in years because you may have added beneficiaries years ago, sometimes decades ago, never updated them. And then when you pass away, that creates a real dilemma. Let me tell you about a matter that we had a couple of years ago. That is, we had a client to come in. Her husband had recently passed away. They had been married for 8 years. And again, he passed away unexpectedly. He was young, he was under 50, as I recall. And he had a $500,000 life insurance policy. Although he'd been married to the second wife for 8 years, he never took the first wife's name off as a beneficiary. And once he passed away, first wife was entitled to the $500,000 tax-free lump sum death benefit from the life insurance policy. Well, the second wife was my client, and she was devastated. And there was nothing she could do. There was nothing we could do. He had not changed the beneficiary on the life insurance policy. The first wife was entitled to the money. And I can just imagine the first wife saying, serves you right, I'm entitled to it anyway. But you have to make sure that you have updated current beneficiaries on every single financial account that you have. That's going to keep all that money out of the expensive, complicated probate process. Another part of this is your loved ones need to know where the accounts are. We get so many calls when people pass away and people are saying, can you help me find the accounts? Can you help me find the life insurances? And the answer is no, we can't help your loved ones find your accounts. And normally I would advise my clients to keep your eyes on the mail because, normally clients are still getting monthly statements or possibly even quarterly statements from some investment accounts. But these days, so many people are doing online banking and you don't get the monthly mail statements any longer. And so we can't even advise our clients anymore to just keep your eye on the mail because the statements are coming in. And so if your loved ones don't know where the accounts are, they cannot collect the money. And more money than ever is now going to the state because when people pass away, the loved ones just don't know where the accounts are. So what we give our clients is what's called an estate plan and inventory book. And that's a book that we give to every single one of our clients where they're going to list all the accounts that they have in the book. They're going to list all the beneficiaries in the book. They're going to list the account institution and the account number. You don't need to list the balances because your loved ones don't need to know that until they need to know. If you list the balances and they see the balances in the book, then they're going to want to borrow an extra $1,000, okay? Where they haven't even paid you back the first 1,000. So they don't need to know the balances, but they do need to know where the accounts are. So the easiest way, most efficient way, free way to keep all of your financial accounts out of probate court when you go to heaven is to make sure that you have current beneficiaries on all of them, and then to list the accounts in the estate plan and inventory book that we give all of our clients, and then you're going to be in great shape. Just like the real estate, we never advise our clients to put their children's names on their financial accounts. That is an absolute no-no. We've seen horrible things that children and grandchildren have done to their grandparents and parents because their names are on the accounts. They've taken huge sums of money, unbelievable sums of money, because their parents and grandparents added them as signatories on their accounts. We never advise our clients to do that. Please don't add your loved ones' names to your real estate. Please don't add their names to your bank accounts. We want them to get the money after you. We want you to maintain exclusive control of your real estate and of your financial accounts until you go to heaven. and then whatever left, then they can get it after you, but we don't want them to be added while you're living. Let me give you one quick example of what I've seen. I had one client that came in, the whole family, in fact, came in, brought dad in. Dad was suffering from just a little bit of dementia. And dad had added one of the son's names to the account. Well, they came in on this day and they had just discovered that the son who was on dad's account had taken out $85,000. Okay, and they were just blown away by it. And so I advised them, you know what, you should actually go back and look and do an audit of dad's account to see if there's any other money taken out. They went back and did an audit of dad's account over the previous years. The brother had taken out another $100,000 from dad's account that no one knew about. So in a year's time, the son took out $185,000 from dad's account, and he had the legal right to do it because his name was on the account. So we never want you to add anyone's name to your account. And so the question is, well, what happens if someone needs to make decisions for me? Or what happens if someone needs to write checks or pay my bills? Does anyone have an answer out there? I'm trying to see if you're listening today. Well, some of you are right. Yes, that's what the power of attorneys are for. That's what the property power of attorney is for. It allows someone to write checks, pay bills, get information on your accounts, except to deal with Social Security, deal with pension, but it doesn't give them an ownership interest in it. They still have a fiduciary duty to you to make sure they are operating in your own benefit. But if you add their names to your account, they don't have that same fiduciary duty. They become an owner of the account and they have all the rights to use sums of money out of the account. And I've seen it too many times. So we never want you to add anyone's name to your real estate, and we never want you to add anyone's name to your financial account. But one of the ways to keep the money out of probate court is, again, just making sure that you have current beneficiaries on all of your accounts. Now, some of our clients have done pretty well for themselves. Some of you have done pretty well for yourselves, and you don't want your loved ones to get the money all in a lump sum. So for you, we want to do a living trust for you. Some of you may need a living trust. Not everyone needs a living trust. Living trust is kind of an additional fee, but not all of you need living trust. Here are the people that need a living trust, whether it's an additional fee versus some of you who just need to make sure that you have current beneficiaries on your accounts. It's free to do. So living trust versus beneficiaries on the accounts. Here are the people that should consider a living trust. These are the things that you should be considering. Well, one, if you're leaving money to special needs loved ones, then you're going to need a living trust. Because if you leave money to special needs loved ones, that will jeopardize their SSI benefits. But if you leave the money through a living trust, they'll still get the benefit of the SSI benefits and still get the benefit of the money that you're leaving them. So that's one of the reasons why you would want to invest in a living trust is if you're leaving money to people with special needs who are collecting SSI benefits. We just had a client in a month or so ago. Sister passed away. She had never been married, no children, left about $500,000 to 3 of her siblings. And she left the money through a living trust because one of the brothers is special needs. So she still wanted him to have his portion of the money, a little bit more than $150,000, but she wanted it managed by one of the other brothers so that it would not jeopardize his SSI benefits. Okay, so if you're leaving money to special needs loved ones, yes, you need a living trust. Other people that need a living trust versus just having beneficiaries on your accounts are if you're leaving money to minor children. You cannot leave money to minor children. You cannot leave minors as beneficiaries on your account. If you do that, it's going to cause another step that's going to cost the loved ones who's going to manage that minor children money, because now you're going to have to go through the process of being appointed that minor's guardian. That money's going to go into an account for that child, and the child will get that full amount at 18. And you probably don't want an 18-year-old getting a lump sum of money. I'll give an example. Just had a client in, just got an email from a client today. His ex-wife passed away, very young lady. She had a 14-year-old daughter. She left the daughter as a beneficiary on some accounts, probably totaling close to $1 million. Well, the dad can't collect that money for the child. he has to go through the process of being appointed her guardian. And then he's gonna have to get a bond, more fees to collect the money, to put it in a secured account for the daughter until she turns 18. And at 18 years old, she's gonna get this $1 million or so, unencumbered lump sum, no supervision over it. So no one wants an 18-year-old to get $1 million. So I'm sure she thought she was doing the right thing by naming her daughter as the beneficiary, but that was an incorrect thing, because now her dad has to pay me to go to court to have the daughter appointed as a guardian. It's gonna cost a lot of money. It would have been much simpler to set up a living trust, name the daughter as the one that's going to get the money. You could have laid out the condition that was going to entitle her to the money, $25,000 per year for college, give her X amount of dollars when she graduates, X amount when she turns 21, when she turns 25, on and on and on. With a living trust, you can be very specific about the conditions that people must meet that would entitle them to the money. But you never want to add a minor as beneficiaries, because they cannot collect the money, and then their guardians are going to have to go to court to get in a position to collect the money from them, all along paying who? The lawyer. And so that can be avoided by having a living trust if you want to leave money to minors. Another reason why one would want to set up a living trust as opposed to just naming beneficiaries on their accounts is, again, some of our clients have done well for themselves. Some of you have done well for yourselves, and you don't want your children or your loved ones to get the money in a lump sum. So some of our clients, they don't want their adult children to get all the money in lump sum. So for them, yes, you need a living trust as well. Because with a living trust, you can be very specific about what entitles your children to the money. I'll give an example. We had a couple that had been married close to 50 years. They had 2 adult sons. They were twins, 2 good sons. One was a military captain. Another was a some sort of scientist, high quality sons. These were 2 retired educators. Both of them were retired principals. They had about $3 million in combined in their accounts that they were leaving to their sons. Well, they did not want the sons to get the money in a lump sum, even though the sons were 30+ years old, professionals. They wanted the sons to get the money incrementally. So what we did was we set up a living trust for them where the sons got $100,000 each per year for 5 years. And after the 5th year, they got their full balance. So they would get basically $500,000 over 5 years. And at the end of the 5th year, they each got roughly $1 million. Because the mom in particular did not want the sons to get this lump sum of money and not know how to manage it. So her position was, if they get the $100,000 incrementally once per year, by the time they got the lump sum at the end of the 5th year, they would know how to manage it better. So those are the reasons why one would want to invest in a living trust. There's a fee versus just making sure you add beneficiaries on all of your accounts, which is no fee. Again, if you're leaving money to special needs loved ones, yes, you need a trust. If you are leaving money to minor children, yes, you need a living trust. If you don't want your adult loved ones to get the money in a lump sum, yes, you need a living trust. In my opinion, if you don't have those conditions, you can just leave the money by way of beneficiaries on all of your accounts, and it will keep the money out of probate court. So for most middle-class families, those are the 3 primary things that we want to keep out of probate court for our clients: the real estate, the person, your spouses, your loved ones, people that you may need to be in a position to care for, especially you ladies out there, because you ladies are the caregivers. Ladies, don't find yourself in a position where you need to be in a position to make decisions for someone and you haven't prepared for it by having the documents that allows you to be in a position to make decisions for them. It will only cause you a lot more stress, a lot more money, and it can be avoided by having the power of attorneys. And then the other thing we want to make sure that we keep out of probate court is the money. Again, and we just talked about that. How we do that is, 1, make sure you have current beneficiaries on all of your accounts, and make sure that your loved ones know what all the accounts are. Or some of you may need a living trust. And again, The reason why one would want a living trust versus just beneficiaries is if you leave money to special needs loved ones, minor children, don't want your adult loved ones to get the money in a lump sum. You know what? Some of us, and now I'm reflecting on some of my own family history when I talk about this. Some of us are so private that when we pass away, our loved ones don't know where anything is. They don't know what any of the documents are. And sometimes this even happens among spouses. And some of us go beyond private. Some of us are downright secretive. Well, I'm telling you this now. That doesn't work well for your family because again, when someone goes to heaven, it's stressful enough. And if they don't know what the information is about your homes, your finances, life insurances, etc., it becomes very, very stressful for them. And some of it goes uncollected. And you work too hard, spend your whole life accumulating real estate, accumulating savings and investments account to let it all really, or any part of it, go down the drain. And then you also work too hard to have such a large amount of it or percent of it go to the lawyer handling the probate process. Back to probate for a second. The average cost of probate is about 5% of the value of your estate. Okay, so if you own a home, have money in the bank, just chalk off 5% of the value of it all combined to go through the probate process. Okay, and it can be more because there are going to be some fees, going to be bonds, and then you can almost double that or perhaps even more if there are claims that need to be paid and someone's contesting it. So again, it's really important to make sure that you get your things in order and make sure that your family and your friends and your loved ones have their things in order. So often, Black folks just don't have a lot of information. And so what I discovered again, like I said at the beginning of this, is once Black folks have good information, they make good decisions. But here's what I find. I find that when I go to probate court for my clients, there's so many white lawyers in there. So white folks don't have a whole lot of information either. And a lot of their things are still going through the probate process. And sometimes when I'm in court, I'm just listening to some of the cases that are ahead of mine. And I'm just adding up the fees for the lawyers because I'm hearing about the assets they have, $1 million homes, summer homes, cars, motorcycles, bank accounts, and these people didn't do any estate planning at all. And when I'm hearing about the value of some of these estates, and all I'm sitting while I'm waiting on my case to be called is I'm just adding up the fees, okay? And so these fees can be avoided, but it's not just a Black person issue, it's a white person issue. Only about 1/3 of all Americans have any estate planning. The reality is more Americans have prepaid for their funeral services than they have prepared to transfer the real estate and the monies that it took them a lifetime to acquire. Okay, so please make sure that you get some estate planning done. If you have more information, you can always call us. You can always set up a time to come in for a consultation. You can always ask questions on the chat as well. You know what? That's a good segue for me to go to prepayment for your funeral services and for the funeral services of some of your loved ones. Because again, this information is not just for you today. This information for you to share with friends and family all around you. Because again, so oftentimes people have so much misinformation and they're confused. And one of the things I really try to do is share straightforward information with you. But again, it's not just for you, it's for your friends and family as well. So again, I typically advise my clients to prepay for their funeral services. It's going to make it much less expensive for you and your family. You're going to get what you want. And you know, it's going to bring a sense of peace over you. Here's what's interesting about it. It is not creepy to prepay for your funeral services. My mom prepaid for her funeral services probably at least 5 or 6 years before she passed away. And my mother, she did not want to be buried. She wanted to be in a crypt. So this is the first time I've ever experienced the whole crypt thing. You know, that's the thing where they put the casket into the wall kind of thing. And I have to tell you, I want to be in a crypt. I want to be in a crypt as well. It's really kind of nice. But she wanted what she wanted. She was not going to depend on my sister and myself to give her what she wanted. She wanted to be exactly where she wanted to be. She had pre-planned it, she had scoped it out, she paid for it. And when she did pass away, it made it very, very easy for my sister and myself to manage her service. So prepayment is very, very important these days. Now, here's one thing. Every time my wife and I go visit my mom at the cemetery, at the crypt, which is very nice, very beautiful, very peaceful place, we always say the same thing, that, you know what, we both want to be here. Okay, so my mother has set a precedent for this whole crypt thing. And so maybe about 4 years ago, we were there and we went into the office just to see, because there's some spaces kind of above my mom and in the same kind of crypt area where my mom is. And we went into the office just to get a price. Well, prices were high. But that's what we wanted. But we're like everyone else, even lawyers procrastinate, and we procrastinate as well. And we did not get it, even though we had already decided this is where we want to be, this is what we want. We didn't do it. Went back 4 years later or so, and if we thought the prices were high then, 4 years before, they had skyrocketed. Okay, and so if you prepay for your services, funeral, crypt, burial, cremation is very, very popular these days. Probably at least half of all of our clients talk about cremation. Really, really popular these days. I don't prefer that personally myself. My dad was cremated, and that's what he wanted, and we actually had a wonderful service for him. My sister and I, we rented a yacht, and he wanted to be scattered in the lake. So we rented a yacht. It was a beautiful October day, kind of cool, but it was bright. And my sister brought a basket of rose petals, and we had family members. We had a minister on the boat. We had a singer with organist on the boat, and she sang some hymns, and the minister prayed, and my sister scattered the rose petals and the ashes in the lake. And it was a beautiful, beautiful service. So he wanted to be cremated. And though many people want to be cremated, but the bottom line is, whatever your preference is, you're going to do better if you prepay for it, because it's going to save money, and you're also going to get really what you want. You're going to be really where you want to be. Because one of the things I've discovered about cemeteries is that cemetery locations are like neighborhoods. They do matter. So that's something for you to consider, as well as prepayment for your services. Again, some of you may have parents or grandparents or aunts and uncles that may be aging. You may want to talk to them about prepayment as well, because again, they're going to get what they want, and it's ultimately going to be less expensive if you do it ahead of time. And believe it or not, it's not creepy. It's not creepy. You know, there's no creepiness when you're saying, I think this is where I want to be, and this is how I want to be managed. Not creepy at all. You know what, I want to talk about a couple other things as well. I want to talk about what's called a Medicaid spend down. Everyone should be concerned about Medicaid spend downs, and many people are very concerned about a Medicaid spend down. Here is what a Medicaid spend down is. A Medicaid spend down is when someone goes into a nursing home, typically when they're aging, and the research suggests that over half of all people 65 years or older will spend some time in a nursing home. Okay, and the number skyrockets as we age. So many people will be spending some time in a nursing home. The issue is, how is it going to be paid? Well, Medicare pays for the first 100 days of a nursing home rehab stay. But after the 100 days, then Medicare doesn't pay anymore. Then the issue becomes, who pays for it? Well, Medicaid will pay for it, but Medicaid is a need-based program. And so Medicaid says, if you have assets, a home, money in the bank, then we're going to collect your money and collect the value of your home to pay for your care. We're going to use your own resources to pay for your care until the resources are exhausted. And only after the resources are exhausted, then Medicaid will start paying. So if you go into a nursing home, there's two ways that it's going to be managed. One is you're going to be a self-pay or Medicaid's going to pay. Now, I typically advise my clients who come in for consultation regarding Medicaid, nursing homes, typically for their parents or grandparents. And sometimes the parents or grandparents, they have sizable assets. Well, the reality is someone's going to have to pay. But I would prefer my clients to be self-payors until the funds were exhausted and then have Medicaid come in, as opposed to having Medicaid come in at the beginning and taking control of all the financial accounts and of all the real estate, because then they just gonna, we know they're gonna just use all the money and the resources up. But if you manage it yourself, typically that's done by people's pension and social security. And then anything that doesn't cover, then if they have some savings or some equity in the home, the additional can come from those resources. Now, again, if there's no resources, there's no home ownership, very little in the bank, then again, Medicaid is going to step right in and pay for the care. But short of that, Medicaid wants you to pay for it. And again, oftentimes we see clients who have pensions and Social Security that will cover the cost of a nursing home stay, and Medicaid will never have to get involved. Now, some of you who are married, let's say that one spouse goes into a nursing home facility for more than the 100 days that Medicare would cover. Well, Medicaid is not going to take or put a lien on the home if a married spouse goes into a nursing home and Medicaid pays. So the home is exempt from a Medicaid spend down if you are married. Additionally, if you are married and you go into a nursing home and you stay for more than 100 days that Medicare will cover, Medicaid will let the non-Medicaid nursing home spouse keep up to, I think the number is about $160,000. So if you're married and your spouse goes into a nursing home, Medicaid will not take the home and they will allow you to keep up to $160,000 or so. Anything over that, Medicaid would want to collect to pay for the care. But for my clients, I advise them that anything over and above that $160,000 that's exempt from the Medicaid spend down, I would advise my clients to use the money over and above that to pay for the nursing home themselves, because that allows them to have more control over the resources as opposed to Medicaid getting control over all the resources. And then we know it's going to be depleted. So those are Medicaid questions. A lot of people are concerned about Medicaid spend downs because, again, the research suggests that more and more people as we age will be spending some time in a nursing home. So the issue is, how do you pay for it? Medicaid will pay after 100 days. Medicare pays for up to 100 days. After the 100 days, if you have resources, Medicaid can do what's called a Medicaid spend down. But I would prefer my clients with some resources to be self-payors, to use their money until it gets to the Medicaid level. That way it gives you a little bit more control over the resources. Again, if you have more questions, you can always call our office, 773-721-3333. You know what? I want to talk a little bit about some life insurances as well. I don't know if the African-American community is using life insurance to the best benefit. Normally we see clients come in with, again, have to keep in mind our average clients in the 80 year of age range. So we're typically not getting a lot of 60-year clients in. Most of our clients, 75, 80, 85. We could go ahead, a client in, she was 99 years old, smart, healthy, still bossy. But so this doesn't really apply to some of the older people because, again, at some point, insurance becomes cost prohibitive. But for some of you who are a little bit younger, you may want to consider getting some life insurance, some term life insurance. Some of you may want whole life insurance. I'm not an insurance agent. I don't sell insurance. But I listened to some conversations with some folks in some other communities, and they are making investments in insurance. And people are talking a lot about these days generational wealth. There's a lot of conversation about generational wealth in the Black community. One of the ways that you can solidify generational wealth is through life insurance. And again, life insurance is an investment. I mean, a $500,000 life insurance policy, $250,000 life insurance policy, $1 million life insurance policies, those are investments. But here's one thing for sure, we are all going to pass away. And if you make that investment in life insurance, it's almost like an adage I've heard, it's like planting a tree that you're never going to get the benefit of the shade from. But if you get life insurance, your loved ones, children, grandchildren are going to benefit from the life insurance. So many of our clients that come in 80 years old, they may have $3,000 life insurance policies, $5,000, $10,000 life insurance policies, really the highest I've seen for most of our kind of senior clients. But you have to keep in mind, 30 years ago, 40, 50 years ago, they only sold us barrier insurance for $3,000, $5,000. Heck, we've seen clients who have actually paid more for the insurance over the course of 30 years than the insurance is even worth. But now Black folks are able to get significant life insurance policies. It is something to consider. Again, it is an investment. It is not necessarily an investment for you, but someone's going to benefit. Someone's going to benefit from the life insurance policy. Again, when you talk about generational wealth, life insurance is certainly one way that you can accrue and accumulate and transfer generational wealth to your children and grandchildren is through life insurance. I am not sure if enough African-American folks are really getting the benefit of life insurance. You know what? Here's the good news about, typically my clients are 99% African-American people. So when I have these seminars, I'm talking primarily to African-American people because there's a lot of places, well, there are places that other nationalities can get their information from. So I speak primarily to an African-American audience here. You know what, another thing when it comes to really managing your estate is you need to have some idea about what the value of your estates are. So oftentimes we have people come into our office and they don't really have any idea of how much they're worth. And oftentimes it is considerably more than they thought. When we come in and we go over, because normally when people come in for estate planning, I need to know really what's the top line figure that we're talking about, because I want to help you disseminate it. So we need to know what's the value of your home, how much you have in life insurance, how much in your financial account, roughly. I don't need those particulars because we need to know, should we be trying to give away $500,000, $1 million, or just $50,000? And so we need to have the information. And oftentimes people, when they come in, they don't. And so I think you should take an inventory of what you have. You should take an inventory of the value of your home, how much equity you have in it. Is there any mortgage on it? How much you have in life insurance, how much you have in your financial accounts. And you should probably do that every year, every 2 years, just to make sure that you have a rough top line figure about the value of your estate. Some of you will be surprised. Okay, some of you will say, wow, I didn't know my house was worth this much. I didn't know I was so close to paying it off. Man, I didn't realize it was paid off. I didn't know I had this much in my 401k, my IRA, my mutual funds, my stock accounts. I didn't remember, I forgot that I had this life insurance policy. I still have it. That's another $50,000. I mean, some of our clients, they actually forget that they have some of these accounts. And so I think you want to take inventory of all of your financial accounts just to get a rough idea of what you're worth these days. Some of you will be surprised. Some of you own businesses too. So let's talk to some of you business owners out there, because we see this over and over and over again. We see business owners who have businesses and they have LLCs, and some of them have assets in the LLCs, some of them have real estate, some of them have cars, some of them have financial accounts, some of them have savings and checking accounts in LLCs. And what we find is when they pass away, they have not taken the secondary step to transfer that LLC and the value of it to their loved ones. And so the issue is, just because you have a corporate document, an EIN number, and you have an organized LLC, that has not set up the transfer of the value of that LLC to a loved one. So the issue is, how do you transfer the value of an LLC, whether it's real estate, cars, vehicles, trucks, financial accounts, to your loved ones after you go to heaven? And that is, you have to have an operating agreement. So if you have an LLC, but some people have LLCs with no assets in them, but some of you may have LLCs with assets in them. So for those of you who do, you have to have an operating agreement that goes along with that LLC. And in that operating agreement, you're going to list who's going to get the share of the LLC once you go to heaven. Again, you can name multiple people, a sole person, but it has to be someone, because if you have an LLC with no operating agreement that lists who's going to be entitled to the value of the LLC once the person goes to heaven, what's it going to have to do? Where's it going to have to go? It's going to have to go through the probate process. And then who's going to get 5% of the value of the LLC? The lawyers. Who's going to be happy? The lawyers. You can avoid it just by making sure if you have LLCs, you have an operating agreement along with the LLC. And in that operating agreement, you're going to detail who's going to get the value of the LLC once you go to heaven. Again, we don't necessarily want to add someone's name to the LLC as a co-owner or co-interest holder with you, but we do want them to get the assets very easily once the person goes to heaven. I see we have a couple of questions here. We only have a few more minutes. Let me take some of the questions here. So talk a little bit about assets that are commonly funded into a trust and the consequence of having a trust with unfunded or untitled assets. So good question. And so the question is, what are some assets that are commonly funded into a trust? Well, real estate is funded into a trust and financial accounts. Those are the two most commonly assets funded into a trust, real estate and financial accounts. And so the other question is, what happens to accounts that are unfunded in a trust? Well, if you have a trust, first of all, you do have to transfer the assets into the name of the trust, because if you don't, then the trust doesn't control it, and then that can lead those assets to go through the probate process. That's why typically I don't like our clients to do the DIY thing when it comes to estate planning. That is the do-it-yourself thing. You really do need a lawyer that's going to be very clear with you and explain to you what it is you're doing. And that's all based on what you're trying to accomplish, because people are trying to accomplish different things. But don't try to do this yourself, because what we find is when people try to do these things themselves, they make errors, and then when they need it, and it's really important that it's done correctly, it's not. And then sometimes it's too late for them to correct it because the person's passed away, the person's no longer competent, and then it makes it a real issue. Question is it a good idea to have multiple owned properties under separate land trusts? Or does combining multiple properties under one trust number undermine the purpose of maintaining the anonymity of the trust? In the event ownership of one of the properties is discovered, then all the properties will be discovered? Another really good question from the anonymous attendee. Typically, again, I typically don't object to my clients have multiple properties in the same trust because I like to try to keep my clients' fees down. The only time I would typically advise my clients to set up separate trusts for separate properties is if they're going to different people. So if you have multiple properties, you want one property to go to one person, another go to another to another, then we know that we want separate trusts. But I do not object to multiple properties being into the same trust, because again, it allows my clients' fees to be a little bit lower than doing multiple trusts. Another question, I have a digitized copy of a will. It makes it easier to read and also say the typed up in a thumb drive. So this person is saying that they have a digitized copy of our estate planning booklet, which is a good idea. And they said it makes it easy to delete and edit important information. And they say they have the entire document saved on a thumb drive. Well, that's a good idea. But one of the important things is your loved ones still need to know that this exists and where it is. Because just because you have it on a thumb drive, people may not be going through jump drives and putting them in and looking at them, et cetera, et cetera. I am still a paper guy. I still like my clients to have the paper, put it in a file cabinet, let someone know that you've done the estate planning and where it is. But a thumb drive is certainly a good idea. That is okay, but I would still like it coupled with paper, and someone still must know where it is. They must know that you've done some estate planning. Otherwise, it really doesn't do anyone any good that you've done it and they don't know that you've done it and where the documents are. Now, they don't need to know the specifics of it, but they do need to know that you've done some estate planning and where the documents are. Another question is, what if you have a joint bank account with your spouse has become incapacitated? How do you get a beneficiary assigned to the bank account if you don't have a power of attorney document? Because if something happens to me, what will happen to the money? Great question. And so that question begs what I talked about earlier today. You have to get this power of attorneys done before it's too late. You cannot wait. So the question is, what if you have a joint bank account, spouse is incapacitated, it's going to require 2 signatures on a joint account to add a beneficiary, and the spouse can't sign, and you don't have the power of attorney to sign for her. Well, it makes it very, very difficult. Typically, in that case, questioner is, I would just advise you to open up a new account solely in your name, take the money out of the account, the joint account, transfer it to the new account, and then just add a beneficiary that way. If you're still loving spouse, you're still going to take care of your disabled spouse, having the money in your name solely is not going to be an issue. But I would take the money out of the joint account, put it into a separate account, and add the beneficiary that way. Pearl Ramsey, I see a hand. Is there a question? Jada, does Ms. Ramsey have a question here? Got it. Okay. Let's see.
I'm sorry.
Yes.
No, that was an accident. I'm just listening.
No worries, Ms. Ramsey. You know what? I want to talk a little bit about dementia too. You know what? Dementia is really rampant in our community. We're seeing it so often. So you have to keep your eyes on your loved ones, on your spouses, heck, even on yourself. Because again, we have quite a few people who loved ones have dementia, and they come in, they want to get estate planning done for the loved one with dementia, but you know what? They are not competent. So a person has to be competent to do any of what we're talking about today. And we see very often that people bring their loved ones in and they are just no longer competent. Now, just because a person has dementia does not preclude them from doing estate planning, because just because you have dementia doesn't per se mean that you are a person isn't competent. But I've had families come in and they bring the loved one in, and I sit them down, I have a conversation with them, and it is just clear that they're just not competent. Family, I'm sorry, we're not going to be able to do anything because they just don't understand what we're talking about here. And so we just can't. So again, if you have family members, loved ones that you see that they're aging, memory slipping, some signs of dementia, then you want to get them in. Now, men are the worst. Men are the worst. And I see some men on here today, Craig, Kenneth, Charles, always happy to see men, because men are the absolute worst to come in and get their estate planning done. But here's what's so interesting about men. When the families bring Albert, when the families bring men in to get the estate planning done, sometimes it's children, sometimes the wives, because women are the ones that are driving this process in the African-American community. What's so interesting is when I do a lot of speaking engagements in non-African-American communities, men are the ones that's driving the estate planning demands for the family. But in Black families, it's women. So I'm always happy to see you men, but for you ladies, sometimes these men are difficult. And so the way I would advise you to manage a difficult person is don't overwhelm them with information. Just say, let's go see the lawyer and let's get information. Because oftentimes people are like my grandma. If you try to give them too much information, they think you have a self-interest. And so that's what happened with my grandmother. By the time my grandmother passed away, I was already a practicing lawyer, and I tried to get her to get some estate planning done, and she just would not do it. Every time I talked to her about it, she would just shut down. Ultimately, did not get the estate planning done, discovered that my grandmother had more money than anyone ever thought that she had, and it created a real rift in my family. And so I mismanaged that. I probably should have said, Grandma, let's go see someone to get some information about this. It is important. Everyone knows it's important. But if you start trying to give information to difficult people, then they think you have a self-interest, and then they're gonna shut down. And so that's how you deal with difficult people. Some of you have difficult people, you know what, you know who they are, but you still need to get them in to get some things done. And we specialize in hard to work with difficult people. And the way that I do it is I let them know that you're still in 100% control here. All the decisions are yours. Whatever you tell us to do, that's what we're going to do, but we do need to do something, and that's important. We're gonna take one last question. It's what's my opinion about obtaining long-term care insurance versus using 401k or other assets for long-term care? Well, that's a good question. You know what, questioner, you know what, you have to balance the cost of the long-term care versus the value of the 401k, because you may be able to get the benefit of both. You may be able to fund a long-term care insurance and then not deplete the 401k. So I would price long-term care insurance, again, take stock of what the value of the 401k is, and you may be able to get long-term care insurance without depleting the whole 401k account. You know what, I think our time is up, but I'm gonna see if there are any other questions we want to take. Again, we do this every first Thursday at 11 to 12:15. Some of you may know that I do a radio show every week on the Legal Line, WVON 1690 AM. That's every Thursday. Actually, that's gonna be this afternoon. So this afternoon from 3:30 until 4, I'll be on WVON 1690 AM. I know some of you are our listeners. Again, you can also go to our link tree, LINK. I think Jada just put it on the screen there. And then you'll see our TikToks, our Google business page, our website, YouTube channel, just more information. Again, you can always call our office. Again, number is 773-721-3333. If you have some friends and family that weren't able to make it to the seminar today, invite them to the next week's seminar. You can always call Jada at our office, and she can help you line up getting your loved ones registered. And if you have organizations and groups that you would like us to come and share information with, or do a Zoom seminar just for your group, call Jada and she can help facilitate that as well. Again, I appreciate you all for joining us this Thursday afternoon. And again, if you're available, if you have the time, tune in today at WVON 1690 AM at 3:30 for the Legal Line with Attorney Ted London. Thank you all so very much. And if you need us, please call us anytime. Thank you.